how to call BS on debt collectors, receiving a summons to appear in court, and why you don't want to ignore this issue. I'm Joe Chavarria, and welcome back to another exciting episode of Cup of Joe. So today the topic at hand is what to do if a debt collector sues you. And before I go further into this, I want to throw out my disclaimer that I am not an attorney. This is not legal advice. If you are, in fact, being sued by a creditor or by a debt collector, you should want to seek out legal counsel, and I advise that you do that. Also, I want to remind everybody before I dive into the content here that you be sure to like, share, and subscribe to this information. And if you are currently being sued by a debt collector, comment yes or comment no if you're not. Just want to get an engagement of what my audience is currently going through, what kind of questions or concerns does my audience have, and so I can continue to provide content that resonates well with my audience. All right, so let's get started. So point number one is how to call BS on a debt collector. How do you know if a debt collector is BSing? BSing, by the way, stands for bull crap or bull. I'm not gonna say it, but it's a curse word. And just how to know if they're lying, basically. How to know they're not being truthful. How to know they're just making empty promises or empty threats. How can you distinguish a legitimate lawsuit or an attempt to sue versus just blowing smoke and just trying to scare you and intimidate you to paying? So first and foremost, let's kind of start the ground there. Let's kind of build from there. Is that debt collectors, not all the time do they do sue. They can make threats about it or hint about it and make it appear that they are going to, but it's really just an intimidation tactic to get you to pay them something. And so how to some indicators that would give away that they're not really being serious or it is just blowing smoke is if they say that if you don't pay we're going to sue, or any type of hint at litigation. Many cases, not all, but many cases, they're just blowing smoke. Like if most debt collectors and creditors who do sue usually don't give you warning that they just do it. Okay, so if you have a debt collector that is making empty threats or just promising to sue if you don't pay, what you want to do as a consumer is kindly just tell them, hey, that's great and all, but if go ahead and everything you're telling me, everything you're talking about, go ahead and put it in writing. I don't wish to speak with you further on this matter. If we're talking about litigation, if we're talking about litigation at this point, I probably would want to get an attorney involved in this matter. So if you are going to sue, go ahead and send me something in writing to verify that you are. If not, we have nothing else to speak about. So if they're threatening that, tell them to put it in writing. Tell them to put their money where their mouth is and back up what they're saying. If not, again, they could just be blowing smoke, just trying to intimidate you into paying. So don't fall for that trap. Don't ruin your day. Don't get all stressed out or all anxiety haven over this debt collector that could just be making false claims and empty promises. Another reason why you want to have them put it in writing is if they somehow violate the Fair Debt Collection Practices Act by posing to be an attorney or law enforcement or threatening something, and you can somehow get it in writing, whether it be via email, text message, or U.S. mail, something that's documented that looks like they are violating your rights or they are violating the FDCPA. Now you have some documental proof that you can then pass over to an attorney, and they in turn could probably sue that debt collector, that creditor on your behalf. And in this case, the tables are turned to where you potentially could get the debt forgiven and possibly even put some money in your pocket from the FDCPA violation. Again, speak with an attorney about this, but this is the main reason why you want to get it documented, so you have some physical, tangible proof of that debt collector violating the FDCPA. So if you are getting phone calls or text messages or emails that are like them hinting that they're gonna sue, take it with for what it's worth. Take it with a grain of salt. That usually any kind of debt collector that threatens litigation, they usually don't threaten it. They just do it. And most of the debt collectors that do sue, they're typically debt buyers. So that would include Midland funding, lvnv funding, portfolio recovery. Those are the three main big players in this space, the debt buyers that actually do purchase debts. They buy high dollar amount of debts, and then they do pursue litigation if a certain amount of time has passed and they feel like there is a good case. Most other collection agencies, some of the low level ones, especially ones that have low dollar amounts that they're collecting on, usually they don't pursue litigation because of the fact of how much it is, what will cost them. Is it really worth it? Typically, we're noticing that debt collector will sue on accounts right around $1,500 or more. Anything below that, you kind of are into some territory where it may not actually be worth it for the debt collector to go through that process. A lot of them would prefer just to try to collect the debt via phone call, via text messaging or emailing or letters, trying to get you to make a payment, or credit reporting as well, threatening credit reporting, bad credit reporting as opposed to threatening lawsuits. But some of the bigger players like the Midland fundings, the lvnv fundings of the world, portfolio recoveries, these debt buyers, they tend to litigate on debts that seem to have a good case and would be worthwhile. So if you have a debt collector that's threatening it, again, ask them to put it in writing. And if they somehow aren't serious about the litigation, but they put in writing that they are, or they're pretending to be law enforcement or an attorney, then that could actually violate the FDCPA, and you could be they could be liable for that, and you could actually win something there. So now I want to talk about if you do receive a summons to appear in court. So typically, if the lawsuit is legitimate, you will receive a summons to appear in court, which could be served to you by a process server, a sheriff, and sometimes a constable. Like, they will actually physically find you, physically go to your house or to your work, serve you paperwork, serve you court documents to appear in court. There would be a court date and all that stuff. That means that the lawsuit actually has been filed, and now they need to physically serve you and notify you of the lawsuit so you can appear in court and defend yourself. So if that happens, that more than likely it's a legitimate lawsuit. And what your options are around that, which I'll get into it here in a little bit. But first and foremost, you don't want to ignore it. You don't want to ignore that matter. It's a serious matter. But some ways to kind of like confirm it's legitimate is there's two indicators. One, if you're getting solicited mail from other law firms or other attorneys, like talking about, this case or this creditor, or them representing you in this case. If you get that kind of solicitation from other law firms, that's a good indication that there is something filed against you, because normally when they solicit their services, the attorneys do, they do it because they receive some sort of notification that there was a lawsuit filed on this matter, and in order for them to pick up the case and get business, they solicit for your business. So if you start to see that kind of solicitation come through, that's a good indication that there is in fact a lawsuit filed against you. Another thing too is if you do receive paperwork, or if you do get that solicited mail, usually they'll provide like a case number, and you can go into your county website, you can pull up the case number, and you can look to see if there is something actually filed online. If there is no online available in your county, or it's tough to find, you can just call your county office and give them the information. They can look it up and verify there is in fact a lawsuit filed. So if that does happen, you immediately want to speak with an attorney around that matter, because again, you don't want to ignore that and let that fester. So that kind of brings me to my last point, which is why you don't want to ignore this. If you ignore the lawsuit, then the creditor more than likely is going to win by default. Because you didn't show up, because you didn't get a chance to defend yourself, that creditor is going to win by default, and whatever the judge decides, whatever the amount that they're seeking, and whatever route they seem fit, or the judge seems fit to collect the debt, then that's what is going to be awarded to them. And so you really want to take the time to defend yourself. You don't want to let them win by default. If they win by default, some things that can happen around that would consist of maybe a wage garnishment, depending on what state you're in. A bank levy, also depending on what state you're in, where they can try to put a lien on your bank account or a hold on your bank account for the funds that are due, and then extract those funds, directly to the creditor. So you don't want that happening. Or they can put a lien on some kind of property, depending on what state you're in. They could put a lien on a house, put a lien on a business, put a lien on some kind of asset that you own. In the event that they win by default, you don't have a chance to defend yourself. And this is another reason why you want to seek legal counsel. You want to get in touch with an FDCPA attorney, or any attorney that deals with this type of matter. It's called consumer debt. So any attorney that deals with consumer debt matters, you want to get in touch with one of them, go over your options, let them represent you in court, or let them do what they need to do to respond, because that's another thing. They need to respond to that lawsuit, so there's at least an answer filed, and then there's going to be a process behind the scenes that the attorneys will go through. Many of them will show up to court for you. Many of them will try to fight it outside of court for you and go over all those options with you. Whatever it is, you just don't want to let it fester. You don't want to ignore, and you don't want the creditor to win by default. You do have rights, and there's times that the debt collectors, the attorneys can do something for you that may result in the case being completely dropped, or the debt amount being completely reduced significantly, and you're just having to pay a settlement or pay a lower amount, and everybody's happy. Because keep in mind, in America, in the great country of America, you can sue anybody for anything, right? But the issue is, can you collect, right? Collecting is a whole nother story, and I'm sure you've heard that before. You can sue anybody for anybody. Good luck collecting, right? So that's actually true. So debt collectors, when they're suing, ultimately what they really want is they just want money. So if they think that they're going to get it easier outside of the court system, then they're going to save that trouble, save that time, and just work out something directly outside of the court system to receive payment. But a lot of them file lawsuits if there has not been any kind of remedy, no discussion around resolving the debt. They look at it as going to the courts as the last ditch effort to try to collect and get your attention. But many debt collectors are open to just completely dropping the case if there's some type of payment plan, in motion, or some kind of promise to pay, and they would rather go that route because it actually would be better for them, whether it be via time getting the money, or the way that they're getting it would save them some money. They'll actually be able to collect more outside of court. So if you need information on a good FDCPA attorney, if you are being sued and you want to get a consultation set up or contacted by a very good FDCPA attorney, send me an email to joe@creditagents.com, and I'll be more than happy to share a couple of good, reputable attorneys that may be in your area that I know do good work. And depending on what state you're in, I can make that recommendation. The attorneys I do work with are licensed in a lot of the different states. So if you are being sued and you want some legal help here, send me an email, and I will, and let me know what city and state you're in, so I can make sure that the attorney that we know and would recommend would be licensed in your area. And also, final plug is, if you aren't being sued or you're not really worried about this, but you have some credit issues you're concerned about, feel free to visit our website. My team and I are happy. We're always on standby to assist all of our clients. Reach out to us for a complimentary credit consultation. Go to our website, www.thecreditagents.com. That's www.thecreditagents.com, or send us a text message to 281-756-7060. Give us your name, give us little details of what you're looking to accomplish and what you're dealing with, and one of my team members will reach out to you to schedule your complimentary credit consultation. So again, that website is www.thecreditagents.com. That's the as in THECREDITAGENTS.com. Or send us a text message to 281-756-7060. Give us your name, tell us a little bit about what you're dealing with, and one of my team members will reach out to you to schedule a consultation. Thanks for tuning in, guys. Hope this information was helpful, and I'll see you on the next one.